Across the United States, thousands of tenants are charged pet rent, pet deposits, and monthly pet fees simply because they have an animal living in their home. Most landlords use standard lease templates that automatically categorize every animal as a pet, and unless a tenant speaks up, those fees continue month after month. But emotional support animals and psychiatric service animals are not pets. They are disability-related supports. Psychiatric service animals are trained to perform tasks that directly mitigate a mental health disability, and emotional support animals provide clinically recognized therapeutic benefit. Both fall under federal disability protections, not pet policies. The problem is that most tenants don't know this distinction, and most landlords never take the time to explain it. Under the Fair Housing Act, emotional support animals and psychiatric service animals are classified as assistance animals. Assistance animals are treated as disability-related equipment. That means they are viewed in the same category as a wheelchair, a mobility aid, or any other tool that supports a person's functioning. Because of this classification, landlords cannot charge pet fees, pet rent, or pet deposits for an ESA or a PSA. They also cannot apply pet rules, pet weight limits, or breed restrictions. These animals are evaluated under disability guidelines, not pet guidelines. This distinction is the foundation of your protection. So how do these illegal fees happen? In many cases, it's not intentional. Landlords often rely on outdated information or generic lease templates that automatically include pet charges. Some landlords assume that all animals fall under the same category. Others simply hope tenants won't question the fees. And because these charges are often small monthly amounts, $20 here, $50 there, they add up quickly. Over the course of a year, tenants may pay hundreds of dollars in fees that should never have been applied. Over several years, those charges can reach into thousands. Now, let's talk about the part that actually helps tenants. Communication. You do not need to argue. You do not need to threaten legal action. You do not need to send long, complicated letters. You simply need to use clear, factual terminology that accurately describes your animal's classification. Here is the exact phrase that helps tenants communicate their rights professionally and effectively. This is a federally recognized assistance animal, classified as disability-related equipment under the Fair Housing Act. This statement is calm, factual, and non-confrontational. It tells a landlord three things. First, the animal is an assistance animal. Second, it is federally recognized. Third, it is classified as disability-related equipment, not a pet. Most landlords adjust their records immediately once they hear this terminology because it clarifies the category the animal belongs in. Once you communicate this clearly, most landlords will remove pet fees from your account. Some may ask for documentation, which is normal. Others may need clarification from their property manager or corporate office. The important thing is that you've stated the correct classification. You've done your part, and you've done it professionally. Disabled tenants deserve accurate information and fair treatment. Emotional support animals and psychiatric service animals cannot be charged pet fees, pet rent, or pet deposits under federal housing guidelines. These animals are recognized as disability-related supports, not pets, and tenants should never feel pressured, confused, or intimidated when communicating that distinction. If you need additional guidance, support, or therapeutic resources, visit carehavenpets.org. You'll find structured educational materials, clinical interventions, and practical tools designed to help you navigate these situations confidently and protect your rights. And if you want more educational content about psychiatric service animals, emotional support animals, and tenant protections, subscribe and follow for future videos.